Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. The U.S. Securities and Exchange Commission, SEC, charged Ripple and its officials with violations of securities laws in 2020 for using proceeds from the sale of XRP to finance the company's operations. It said that the blockchain payments business should have filed paperwork to get the asset officially recognized. The prolonged legal struggle has waited for a verdict for almost 2 years. ARK Invest CEO CATHIE Wood has shared her thoughts on the verdict. According to her analysis, the SEC is likely to lose the lawsuit. Yet she offers no justification for this assumption. In a recent interview, Wood detailed the SEC's previous court defeats, saying, "It looks that the SEC could be on the road to losing the Ripple lawsuit as well." It's important to note that recent court decisions seem to side with the blockchain payments startup in the ongoing legal struggle. According to the news outlet, Ripple's chief legal officer Stuart Alderodi said the company's confidence increased with each ruling after Daubert motions were dismissed by Judge Annalisa Torres. In addition, Ripple has recently filed letters wherein it cites decisions from other cases that support its fair notice defense. The SEC has apparently answered these letters at long last. The judge in Voyager's bankruptcy case made certain words that were used in Ripple's response, but analysts remarked that the response did nothing to undermine Ripple's claims. As a friend of the court, attorney John E. Deaton represents thousands of XRP holders in the ongoing legal dispute, and he has informed the community that a verdict on so-called summary judgment is imminent. Wood's recent comments were made in response to questions regarding the feasibility and time frame of a U.S. Bitcoin spot ETF being authorized by the Securities and Exchange Commission. Using quotes from judges in the Grayscale appeal, the head of ARK Invest criticized the commission for being inconsistent in their approval of Bitcoin ETF products. As was mentioned in a prior piece, courts questioned the SEC's rationale for approving a futures ETF, but rejecting a spot ETF despite both having similar fraud safeguards. As a result, Wood believes that Grayscale will get a favorable verdict in June. She said the SEC would have to decide between rescinding its approval of the Bitcoin futures product or allowing the Grayscale spot ETF. You may recall that Wood's ARK Invest, in conjunction with 21 shares, has twice filed an application for a Bitcoin spot. The SEC has twice denied the offering, most recently in January. The blockchain company Ripple and the Securities and Exchange Commission, SEC, seem to be nearing the end of their legal battle, according to a growing consensus in the cryptocurrency world. The case's resolution is widely anticipated to affect the future course of crypto market regulation, particularly with regard to securities categorization. As of March 27, a tweet from pro-Ripple attorney John Deaton predicted that a decision will be issued by the court within the next several weeks. If not this week, Deaton claims there is nothing to lose for XRP even if the SEC prevails since the coin offers the best risk-reward. But he said that if Ripple prevails, the fact that XRP is not a security would be established, and the token's value will rise. According to Fox Business, attorneys involved in the case have hinted that the legal conflict might terminate in the next days, thus increasing the likelihood of the summary judgment date. Deaton has encouraged the crypto community to see the lawsuit as an assault on the whole digital asset market and not just a Ripple problem, since he expects the contentious Heinemann speech emails will be opened on the basis of being judicial records. On March 23, defense attorney James Phelan tweeted that the SEC had sent its answer to the defendants in Ripple's letters requesting permission to rely on Bittner and Voyager as additional authority. According to the SEC's reaction, the letter included random thoughts, excerpts from the judge's concurring judgment in the Bittner case, and an order confirming the bankruptcy plan in the Voyager case. However, the regulator said that the extracts do not give any grounds to reject the SEC's move for summary judgment, despite the defendants' claims that they bolster their fair notice position. The SEC's answer to the Bittner case raises some fair concerns, Ripple supporter and lawyer Jeremy Hogan argues. But the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto realm is smirkable. The answer, he said, renders the Bittner judgment moot, but the Voyager judge's judgment is still in effect for Ripple. Both sides are convinced they will prevail in court, so a settlement is a significant development. Bill Morgan, an attorney from Australia, said that all chance of a settlement was eliminated after seeing the SEC's response letter. In the ongoing legal battle between Ripple and the United States Securities and Exchange Commission, the SEC has submitted a response to Ripple's claim citing prior cases and their conclusions that may have an effect on the cryptocurrency business. According to a tweet posted by U.S. Defense Counsel James K. Filan on March 23, the SEC has delivered its answer to the two letters seeking additional authority from the bankruptcy case of Bitcoin lending platform Voyager Digital and the Bittner v. Digital and the Bittner v. United States lawsuit. As part of its fair notice defense, Ripple had previously filed the ruling in the Voyager bankruptcy case, citing Judge Michael Weil's comments on the significant uncertainties in the cryptocurrency industry, on which regulators themselves cannot seem to agree. The second letter addresses the case of Bittner v. United States, whereby a U.S.-born citizen of Romanian descent neglected to declare all of his income to the Internal Revenue Service. Fair notice should be provided to the public in terms that the common world will comprehend of what the law plans to do if a specific boundary is crossed, the court said. The SEC has responded to the defendants' letters, claiming that the reasons raised in them do not constitute a valid fair notice defense and that neither offers any basis to reject the SEC's petition for summary judgment. The SEC has moved for summary judgment, and the defendants have sent letters citing stray words from two instances in objection. Defendants argue that these passages buttress their fair notice position, but none of them is correct. The SEC's legal team argued that the court's decision in Bittner, which addressed whether penalties could be imposed once for each unreported foreign bank account or as a single fine, supported its position that a single penalty could be imposed for the transgression under the rule of lenity, but did not imply that the rule could be used to escape liability. Summary judgments, a settlement between the parties, and a follow-up litigation exploring whether any XRP token sales in the U.S. contained an unregistered investment contract are all possible outcomes previously cited by former attorney and Evernote XRP co-founder Scott Chamberlain. Judge Annalisa Torres issued an initial 57-page ruling in which both the blockchain company and the financial regulator were seeking to exclude expert testimonies from summary judgment, and his recommendations came after what he believed to be a major win for Ripple against the SEC with the fatal exclusion of one specific witness.